The word may is not directory, it's not discretionary, it is mandatory. But my Lord, I told you, this submission on the part of some of the petitioners is refuted emphatically by the history of our Constitution, and I only allude to this history for two reasons. One, my good friend Rod Denning here took you to history. You know, Boma's draft, Wako draft, Kilifi draft, and the many other drafts as the basis for the submission that for the limited purpose of Article 145, May is mandatory. But my Lord, is that submission, is that history correct? Or is it revised history? Or is it history according to the first petitioner? My Lord, when you check Article 164, Sub-Article 4 of the Boma's draft, the word used was shall. If you check Article 155, Sub-Article 3 of the Wako draft, the word used is shall. However, if you check Article 145, 3b, the word used is may. My Lord, you don't need a brain to see the histories. Those who are negotiating our Constitution initially used shall, but ultimately dropped it and used may. So if that is the incontestable history based on the record, where would the court of law have the power to say, we are aware that in Bomas, this was the proposal, we are aware in Wako draft, this was the proposal, we are aware it was dropped in the 2010 Constitution, nonetheless, we are instating it. My Lord, that's why Chief Justice Roberts was asking his colleagues in the US judiciary, just who the hell do we think we are, so that we should be able to do such a thing? Kenyans emphatically dropped shall, adopted may. You're being invited to overturn the choice they made and say it is the ex-ante position that applies. But my Lord, courts also have to be consistent. There is a ruling on record in this very file where I took you through those drafts that my good friend Rod Denning took you through, where I was trying to demonstrate to you that this matter of impeachment was meant for the Supreme Court. And I took you through Boma's draft, I took you through Wako draft, I took you through other drafts. All of them provided that the jurisdiction to impugn such a process would lie in the Supreme Court, except that it was dropped in the last version that Kenyans ratified at the referendum, and this court dismissed that preliminary objection. So if we were wrong then to invoke that history, on what account can the petitioner now be right? My Lord, they are asking you to embarrass yourselves by holding on one occasion the history points this way, but on another occasion it doesn't point, and it's the same history on the same subject of impeachment, same legal text. The court cannot. It cannot do that, not as a matter of consistency. And my Lord, you were told by Mr. Mokele, I believe, that there are other removal provisions in the Constitution. And you are referring to, I believe, Article 152.7, where the word used is shall. So it cannot be that the use of may in 145 is a slip, and therefore this whole idea. You are told, my Lord, that there is a decision of the High Court in Sonko that suggests what Professor Gidu Muigai calls obiter dictum, that maybe the committee route is superior. And of course, Professor Gidu Muigai told you those views are obiter, and he correctly did so. But my Lord, what I found curious is on the record, and I've kept raising this over and over, the petitioners have misrepresented those obiter views as views of the Supreme Court. That's what's written on their submission. Yet it is common ground That is not even a decision of the Court of Appeal, leave alone the Supreme Court. And for that reason also, they can't, and in any event, my Lord, that obiter dictum was emphatically rejected by the Supreme Court in the case of Sonko versus County Assembly of Nairobi and 11 others. If you want the specific paragraph, my Lord, you can read from paragraph 110 of the Supreme Court decision in Sonko and whatnot. My Lord asked a question yesterday. You know, when we say public participation is contextual and whatnot. My Lord, the timelines are part of that context. The idea, my Lord, that any part of this process, whether you go committee route, whether you go plenary route, or indeed any other route, the idea that there is a route you can go and the timelines are open-ended. You can delay it until donkeys grow horns, until the conversion of the Jews, is refuted by the architecture of our Constitution. So any suggestion before you that, Senate was wrong or National Assembly was wrong because they misread this article and then this other reading, I don't know under what grammar, therefore the timelines are open-ended or they are prolonged. There is no country, my Lord, anywhere in the world where a matter going to the very heart of the highest offices in the land, like the matter before you, as open-ended timelines. They didn't show you a single constitution anywhere. I had them take you to Singapore, to South Korea, to Philippines. I was waiting for them to take you to a place where this process has open-ended timelines. On the contrary, the practice the world over, without exemption, is that a process such as the one impugned before you has short, I repeat, my Lord, short and inflexible timelines. You have the 2 days, you have the 7 days, you have the 10 days, all set out in Article 145. For the purposes of my client at their ascension to office, the timelines are also fixed. The president must nominate within 14 days. Parliament must make the vote within 60 days. And my Lord, if a matter can be done within 14 days, by way of example, it cannot be a grievance that it was done on day 1 instead of day 14, or on day 7, or day 5. If the Speaker of the National Assembly had 2 days to refer the matter to the Senate, it cannot be a valid grievance before you that he referred it within 2 seconds. The Speaker should be commended for obeying the philosophy of the Constitution, which is that matters of the nature before us must be expedited, and more specifically, going by the decision of the Supreme Court in Mate and another versus Wambora and another, paragraph 85 to 93 of the Supreme Court decision in Justice Kariuki Mate and another, my Lord, the Supreme Court confirmed that these timelines are cast on stone. They are inflexible. We cannot expand them, not even by an hydraulic mechanism. And the Supreme Court, that's part of the reason, my Lord, the Supreme Court made the unusual order I referred you, where for the first time, because I've never seen this in my entire career, where the Supreme Court upholds the violation of a High Court order, because that High Court order had been made in ignorance of the fixed and inflexible nature of this timeline. My Lord, the attacks against the standing orders, whether it is standing order number 64 of the National Assembly, or the standing order number 78 of the Senate, or indeed any other standing order, to the extent that it is clear these standing orders are actually just rehashing what the Constitution already says. There is nothing new any of these standing orders that are stated that is not already contained in Article 145. So any attack on those standing orders, the invitation to declare them unconstitutional, my lord, is a collateral attack to Article 145 of the Constitution. You're being invited to rule collaterally, not directly, because the petitioners, of course, are smart people. But I was also reminded, my lord, again back to my Swahili, akili ni nywele, kila mtu akona zake. You're being asked to invalidate Article 145 under the guise that you're invalidating the standing orders of the National Assembly and the standing orders of the Senate. But the point, my lord, is it is clear in Article 2, Sub-Article 3 of our Constitution that the provisions of our Constitution cannot be challenged before any court or tribunal. And if they cannot be challenged directly, they cannot be challenged collaterally. So it's a collateral attack against the Constitution. It is not possible. And for that reason, nothing really turns on the idea that there is anything untoward about these standing orders. It is inconceivable, my lord, that the timelines are open-ended when we go through the committee route or through the Senate route and whatnot. And I've already told you there are deadlines even for purposes of my client's assertion to the office of Deputy President. Madam, every word that was made about counts 7 and 8 of the impeachment motion. You are told many things. But the record will bear me out that the first petitioner was acquitted on count 7 and count 8. So, my lord, how can he come to you to complain? You know, count 8 was based on a repealed section of the Penal Code or a section of the Penal Code that had been declared unconstitutional. My lord, he can have 1,000, 1,000,000, 1,000,000,000 complaints about these two counts. The undeniable fact is on the record. He was acquitted. Unless his complaint is that he should have been convicted of these two counts. It is the first time, my lord, I've had a person come for judicial review in respect of a matter that they were acquitted. And that's why I told you I've been wondering, why are we really here? My lord, it seems now straight to the issue of public participation. Somebody has lied to many litigants, not just the ones before you, that if you don't have a cogent case to impugn a public act, just allege public participation, just impute the quantitative and qualitative and whatever other dimensions of public participation. My lord, it seems someone told the petitioners, allege ye public participation first, and everything else shall be granted unto you. It seems that was the promise they were told by whoever. But if that's what they were promised, my lord, it's a false promise, which this court cannot uphold without violating the decision of the Supreme Court in the BAT case, specifically paragraph 96, Roman 8. And in that paragraph 96 of the Supreme Court decision in the BAT case, my lord, Roman 8, the Supreme Court was emphatic, if I may read, an allegation of a lack of public participation does not automatically vitiate the process. Those are not my words. So even if my lords and my lady were to be persuaded on the material before you that there was something wrong with the public participation in this case, that without more would not vitiate the impeachment. Those are not my words. And the Supreme Court goes on, if I may read again, the allegation must be considered within the peculiar circumstances of each case. I guess this is the question my lord was asking yesterday. And the mode, degree, scope, and extent of public participation is to be determined on a case-by-case basis. You are told, my lord, oh, we went initially to counties. We were directed by Justice Mongo to go to the constituency centers. That was done. But I had submissions from the bar that we should also have taken it to the polling stations. It is in the public domain, my lord, that Kenya has about 46,000 polling stations. Parliament has 350 MPs, 67 senators, and grant or take a few staff. How was Parliament to undertake this exercise in 46,000 polling stations? So one of the case-by-case considerations, my lord, you must have is also the resource implications. Both human resources and other resources that were available to Parliament as far as this exercise is concerned. In addition, of course, my lord, to the timelines. But when all is said and done about this matter, my lord, the Supreme Court has told us in the quote I just read that public participation is not a trump card. It's not a magic bullet. You know, in poker and other games, you have that card they call joker that can be converted into anything. That is not what public participation is in the scheme of our constitutional architecture, and the Supreme Court has said merely because it wasn't done or it wasn't done to certain parameters does not, in its words, vitiate. And the point, my lord, is you cannot have a textbook approach, you cannot have a one-size-fits-all approach or a doctrinal approach to public participation. You have to be shown that on the peculiar case before you, this is what is perverse about the issue that was done. And we were taken through the case of Sonko, the same position, the finance bill case. Again, Supreme Court confirmed the same position. But my lord, it must be it must be clear from your record, because it is there, that the National Assembly published notices, invited people at both county and constituency headquarters. It amended those notices in compliance of court orders that were issued by Mongoje. It invited memoranda advertised nationally in various modes. Of these things, my lord, you were told in great detail how they were done. Unless you're being told, the standards are those of angels, not human standards. Parliament is made of human beings. The staff of Parliament are human beings. They are not perfect. And even our Constitution, according to the Supreme Court, does not demand perfect thresholds of public participation. My good friend, Mr. Moses Kipkoge, took you through what is the true essence of the obligation on the National Assembly. It is to facilitate. So nothing really turns on that allegation as to public participation. My lord, this issue of fair trial, I alluded to it, and I've told you the complaint is based on inverted logic and distortion of facts, and more importantly, the opposite meaning of the grammatical language employed in our Article 50, sub-Article 2. Why are we saying it is inverted logic? The petitioner only has a right to cross-examine adversary witnesses. That right was granted to him, and he fully exercised it. He has a duty to avail himself for cross-examination. I think it is Hoffeld, if I recall my legal theory lessons, my lord, who told us the corollary of rights and duties. The duty that the petitioner had, having given his evidence in chief, having enjoyed the benefit of cross-examining his adversary's witnesses, the duty fell upon him to avail himself for cross-examination. So he cannot convert his duty under the Constitution to a right inherent in name. That right was actually on the National Assembly. And my Lord, you'll be turning the text of our Constitution on its head. If you were, I think the petitioners were animated, my Lord, by this ground, and think that's why it has featured so prominently, because Article 25C says the right to a fair trial is one of the rights that cannot be limited. What they forgot is they have to show you, as a matter of fact, that the right was limited and was infringed upon. So again, someone seems to have told them, allege ye fair trial, and everything else shall be granted unto you. Whoever promised them that lied to them, and we must be honest with them and tell them it doesn't work like that. You were told his request for adjournment came at the tail end after he had given his evidence, he had been examined in chief. The only thing that remained was for him to be cross-examined, not for him to give any further evidence in support of his case. That he already did. That he already enjoyed. Let's come, my Lord, to the alleged illness. You know, this thing, my Lord, when I have been reflecting about it again from my Gen Z students, there is something they call mchezo wa town. Mchezo wa town. It means hanky-panky. You know, being a bit too clever. And forgetting akili ni nywele, kila mtu akona zake. Why do we say so, my Lord? You were told Parliament was wrong to deny the good gentleman an opportunity to be cross-examined while he was ill. It's already common ground. No evidence was placed before Senate to prove that illness. It is already common ground that this petition lasted in this court for 1.5 years, was amended multiple times, and no such evidence was produced. It's only last week on Thursday, 1.5 years down the line, that material that ought to have been placed before Senate was now brought before you. Again, somebody seems to have lied to them, my Lord, that merely because they placed some material 1.5 years down the line, it therefore follows that they have demonstrated he is healed. I'm here, my Lord, if you forget everything else I've submitted this afternoon, to tell you with all the humility I can muster, that the material placed here by Dr. Daniel Gikonyo is worthless. I repeat, worthless from an evidential perspective. Why do we say so? One, you are here on supervisory jurisdiction and that material is not before Senate. That material cannot be what this court can use to fault Senate for acting as it did, because you'll be accusing Senate of failing to consider material that was not before it. Dr. Gikonyo admitted yesterday, my Lord, that what he has annexed as Exhibit DGK3 to his affidavit is not a medical report. He admitted it is a summary. You know, my Lord, even if I come from a country where we struggle with the English language, if I tell you this document is a summary, the one I'm holding, my Lord, if I tell you it's a summary of another document, I must surely show you the primary document so that we confirm, one, indeed, that it's a summary, and more importantly, that it is an accurate summary. Dr. Gikonyo conceded in cross-examination that the machines that are used to do the treatments he purportedly did on the first petitioner generate images, graphs, and reports. He admitted that that's not me saying it from the back. And he admitted he has not produced before you that material. In fact, it was more dramatic. He said it was not asked of him to avail that material. My Lord, I would have thought, given the exemplary caliber of counsel that represent the first petitioner, that is the first thing Dr. Gikonyo would have been asked to produce before you. Even if confidentially, they might even have told you, because it's a health matter, we only want it for the court's eyes. That wasn't done. My Lord, we invite you, in accordance with the established principles of the adversarial system, to draw an adverse inference that the reason that material was not produced, whether before Senate or in the affidavit of Dr. Gikonyo, is because that material, if it had been produced, would have been adverse to the depositions in that affidavit. My Lord, the reason they didn't want to adduce it is, if you say I took an echocardiogram and you produce the image, I don't even need to see a doctor. I can just run that image on artificial intelligence and it will tell me whether the allegation that the patient has a heart problem is true. That's the inference we want you to draw, that the reason the primary material was not produced is because a date been produced. All we would have needed is to ask another doctor or run it on a simple laptop, and it would have shown you what is said to be illness is what they call in the disciplined forces malingering. It's a serious military offense, my Lord, in the disciplined forces to pretend to be sick. And it is our humble submission that, given the concession by Dr. Gikonyo and his failure to produce a medical report, the only inference we can draw is that the first petitioner was malingering, he was not sick, and there is no material, just as there was no material before Senate. As I stand here, there is still no material before you. What we have is naked allegations by Dr. Gikonyo, and he himself admitted he has not produced before you the primary document. That, my Lord, Dr. Gikonyo admitted what he produced before you, that summary, was prepared by somebody else. It is not even a summary by Dr. Gikonyo. So it is, first of all, the document itself doesn't prove anything because it's not a medical report. Then it is ESC, to the extent that it is prepared by Dr. Sarita, who has not sworn the affidavit, and more importantly, who on the face of the document is not one of the physicians that allegedly attended to that patient. That affidavit is worthless, my Lord, because on the face of the document, we can't even tell who the patient is. You know, I thought, my Lord, if we respect this court and given the weight of the matters we're presenting before you, surely the document would have identified the patient, either by name, by ID number, by passport number, or any other recognized method of identifying Dr. Gikonyo, of course, tried from the witness doc to tell you many things he should have said in his affidavit about the multiple discrepancies in that summary. My Lord, I asked him yesterday, it was just yesterday, Dr. Gikonyo, how can this document have 2 timestamps? How can it on the left have been prepared at 12:40 p.m. and on the other side at 12:35 p.m.? And his answer was, I also don't know. Of course he didn't know, because the document was prepared by someone else, not him. He didn't tell you, he tried to tell you, how is it that a man in his affidavit who was allegedly admitted for 48 to 72 hours, the discharge summary shows he was discharged 34 days later. That's a discrepancy you ought to have explained in the affidavit itself. My Lord, Dr. Gikonyo admitting to you, he also didn't produce the laboratory report of the supposed blood tests and other tests that were done at the laboratory as per that medical summary. Again, I invite you to make an adverse inference that the reason that report was not produced is either because there were actually no tests, or if the test took place, they showed there was nothing wrong with the patient, and therefore he was not sick. Without belaboring the point, my Lord, I could go on and on. What Dr. Gikonyo gave you was just entertainment. It's not evidence. Not his oral testimony, not his affidavit, not the annexure to that affidavit. Which means, even as we speak, there is no material on which this honorable court can conclude that the first petitioner was ill, and therefore, perhaps Senate would have acted better by granting him an adjournment. My Lord, if that adjournment had been granted anyway, the complaint now before you, I've lived in this country long enough, although I'm not a prophet, the complaint would be that the impeachment was conducted outside the constitutional timelines. You don't need to have lived long in Kenya to know that. My Lord, when you check that discharge summary, it has the 2 timestamps when it was prepared. But even if you accept one and not the other, the most curious thing about it is that the patient was actually, according to the same document on the top, discharged at 1:36 p.m. So how is a patient in the ordinary course of events discharged at 1:36 p.m., but the discharge report and summary is prepared several minutes earlier? You know, in fictional movies, we watch Morgan Freeman and his time warp and other things. I think these people want to imagine we're in that fictional world where we don't follow the laws of physics and the laws of the universe. My Lord, it is our submission that the real reason the first petitioner engaged in this act of malingering to run away from cross-examination is because the cross-examination would have affirmed the counts relating to the bizarre amassing of wealth, the count on corruption and economic crime, He knew if he had dared step on that podium to be cross-examined, he would have no way of explaining how in 2 years he amassed an estate worth $5 billion. It is our submission when you check volume 4 of the impeachment motion, specifically pages 128 all the way to around 135, my Lord. If the petitioner had dared turn up for that cross-examination, it would have dispelled the facade that is his trademark of a honest man. It would have shown the terrible things he had done to his own relatives, including disinheriting his late brothers, children, and widow. These we submit, my Lord, that if it is true that he developed chest pains, which we can never prove, which the medical reports can't prove, these are the things he was afraid the cross-examination would have exposed. And if he had turned up there, we would have pointed to him, page 129 of volume 4, or page 126, my Lord, of volume 4 of the impeachment motion, which would have shown he had forged his late brother's will to make himself one of the beneficiaries. It would have shown accusations that were leveled against him by his co-executors. His co-executors, my Lord, if you read page 128 of volume 4 of the impeachment motion, who are very senior and respected lawyers in this country, and written a letter which came through the same public participation. Maybe that's why they are unhappy with public participation, because it brought things that anyone would rather they are kept under wraps at all costs. That's why you hear mamas as I allude to them. And I'm conscious, my Lord, I don't even want to delve into it because it's not my style of litigation to embarrass litigants and whatever more than they deserve and is fair. The reason he didn't want to turn up for that cross-examination is because that volume 4 showed he started siphoning money from his brother's account before the body was even moved from the ward to the morgue.
I must object now. I must object. He's raising issues that were dismissed. See? And stating them almost as fact, playing to the gallery here. Really. Yes. And pretending that this is not who he is. Really. This charade was these were dismissed. You can't tell us what was going to happen when it was dismissed. Really.
But my Lord is also complaining about counts 8 and 7 which were dismissed in his petition. All I'm trying is to paint a context in which, it's me now speaking, Mr. Macharia.
No.
My Lord,
I think we're going too far.
You are before you a petitioner who for 1.5 years has been saying he was ill. When the evidence is purportedly brought, clearly doesn't pass the muster. It builds upon me, especially if I'm referring to the record, unless they're saying the document I'm referring to is not on the record.
No.
To show you, are they saying, my Lord, volume 4 of the impeachment motion did not exist?
Let's have the Macharia.
What we are saying is this. The issues he's stating almost as facts here before the court are actually not part of the record. They are allegations that were made in the Senate and dismissed. You can now be speaking of what would have happened had somebody been there. They were dismissed. Once they're dismissed, they're dismissed. That's the point. Simple.
I don't have to delve into it, my Lord, because I told you it's not my style. And truly, it's not my style. But the point is, we are inviting you to read volume 4, the pages I've referred you to, and you'll find the real reasons why the first petitioner would not want to turn up for cross-examination and why he would claim he is sick, and 1.5 years later, when he has the opportunity to prove he is sick or he was sick, we got supposed evidence that is really just entertainment. It has no probative value. And so that we don't waste much time, let's move to the next issue. You are told, my Lord, that the appointment of my client or his elevation to the office of Deputy President or his election, whichever word we choose, was done at breakneck speed, and that betrays bad faith, betrays predetermined outcomes, and other 1,000 allegations. My Lord, in your ruling of 31st October 2024, this court has already held that the office of Deputy President is so critical to our governance architecture that the Constitution does not envision it being vacant for prolonged periods. This court cannot, now having made that ruling, be invited, like I pointed with regard to the issue of the Supreme Court, be invited now to find that the appointment of my client or his whatever was done at breakneck speed, therefore that betrays bad faith and whatnot. You're being invited again to embarrass yourselves. And the last time I checked, courts are not in the business of embarrassing themselves. You have held that the replacement must be swift because, to use your own language, there are important state functions the Constitution assigns to the office of Deputy President that cannot be performed by any other officer. You are told that my appointment, or rather my client's, it's not mine, my Lord. I don't think in my lifetime I'll raise that eye. So that was a slip of the tongue. That the appointment of my client, was void for lack of public participation. We've already told you, my Lord, the Supreme Court has held that such an allegation, even if accepted by the court, would not ipso facto lead to a nullification of the process. Those are not my words, it's the words of the Supreme Court. But more importantly, my Lord, my client ascended to this office pursuant to a sui generis pathway. This event that occurred is not an event that is part of the routine and day-to-day functions of Parliament. That sui generis process, my Lord, is an election by the National Assembly. That's why Article 149 says Parliament shall vote. It does not say Parliament shall approve. It says Parliament shall vote on that nomination. And that sui generis process, my Lord, is very different from the general pathway of rising to that office, which is set out in Article 137. They cannot substitute the sui generis pathway for the general pathway because the sui generis procedure in Article 149 speaks to a unique event that does not ordinarily happen every now and then. In fact, in my entire life, it's not been very long. This event never occurred. This was the first impeachment of a deputy president. There are older people in the court, perhaps it has occurred, but the infrequent and sui generis nature should show you, my Lord, you cannot import generic requirements that govern the ordinary day-to-day business of Parliament and say, those general requirements also apply to this sui generis situation. You are told my client was not a member of a political party and therefore he was unqualified. There is one allegation, my Lord, which you can't uphold even if you're persuaded. Even if they were to have evidence. They haven't placed it, but even if the court were to agree they have watertight evidence, this allegation would fail for the reason that this court, in a case called Union of Civil Servants and two others, versus the Independent Electoral and Boundaries Commission. This is a 2015 decision also. This court ruled, my lord, that it is not practicable, it's not a tenable interpretation of our constitution to expect civil servants and other public officers to be Jewish prophets so that they know a vacancy will arise and resign in advance. So even if it were to be found that my client, which is not found on the record, you can't uphold that allegation based on this authority unless the petitioners are telling you my client should have been a prophet to know that the first petitioner will be impeached on this date so that he can join a political party in advance, so that he can resign in advance and whatnot. Nothing turns on the IBC clearances. Again, there is judicial authority that the matter of IBC is one for the Secretariat. We need not belabor the point. The Supreme Court has again confirmed this in Muruli versus Oparanya and 3 others, in Governor of Kisii and 2 others. There are Supreme Court decisions which bind this court, which means this allegation cannot succeed even if proven on the evidence. You have been told many things, and my friend Kenson will address you on them shortly, about the South African decision. They call it EFF3, we call it Falafala, because Falafala was a place, I think, where whatever happened. But the point I want you to note, my lord, is that the text of Section 89 of the South African Constitution is fundamentally different. It is not pari materia to Article 145 of our Constitution. If I may illustrate some of the differences, the South African Constitution doesn't prescribe any procedure unlike our Article 145. It leaves all questions of procedure entirely to the National Assembly. The South African Constitution does not prescribe timelines like those prescribed in our Article 145. The standing orders of the National Assembly of South Africa do not provide for the preliminary inquiry committee of the type that was in issue in the South African case. And the point, my lord, we could go on and on. The removal process in South Africa is fundamentally different from the one in Kenya. Even the legal system is completely different. Although the head of state in South Africa is a president, theirs is actually a parliamentary system. Ours is a presidential system. As my colleague Kenson takes the podium, my lord, I hope I have shown you that this is not the type of case which, even if you woke up in your best mood, you would uphold. Thank you.